Hello everyone, let's start our next class. So far, we have discussed about the basics. We know that if we want to do a particular business, we have to choose one form of business organization, and it may be proprietorship, it may be partnership, it may be a company. And if we decide to choose company to run our business, we have to follow everything according to Companies Act 2013. Moreover, how do we form a company? How do we incorporate a company? That also is governed by the provisions of Companies Act 2013. We know that company is a voluntary association. We have a choice. Sorry. We have a choice whether we want to form a company or not. We have a choice whether we want to do business or not, right? But at times it can be forced upon us. How, ma'am? How can it be forced upon us? See, if I want to start a business, if for example I have this unique thought that I'm going to now sell bottles, fine. Bottles, water bottles. Please don't get your ideas high. I want to sell water bottles. I'm not going to put up a factory or manufacture the same. I'm just going to buy some bottles and sell those water bottles. So I have to now choose that whether I'm going to do this alone or I'm going to take the help of someone, that is, I may partner with someone or I may form a company. I decided to partner with someone. Fine. So we are two partners and we started with this business of selling bottles. Fine. No problem. Soon our business started or witnessed a lot of phases of expansion. So it expands and more and more and more and more. And from those two partners, we went on to being 70 partners. Don't you think it will be a little difficult to handle? 70 partners being governed by that partnership deed. Such a huge business, because if there are 70 partners involved, you can understand the quantum of business will be so high. And such such a big business governed by a partnership deed. As of that matter, some partnerships may not even be registered. So it is not very feasible that such a grand scale of businesses take shape of some weak form of business organization like partnership, right? So at this particular point of time, I will be forced that if you have an association of such a huge number of people, you must incorporate a company. You must continue your business under the shelter of being a company, or as of that matter any other form of business organization which is permitted by some law, by some act. Maybe you can form a cooperative society, not for this case of course for bottles, but otherwise you can do that, right? So you should have something which is permissible, right? If you continue to do that business with 70 partners, your business, your association will be treated as illegal association. Clear? Now, there is one concept of HUF. I hope you all know that. HUF, Hindu Undivided Family. Now, when I'm talking about HUF, it is something which comes into existence, although it has to be registered, there is an affidavit, all those formalities are there, which brings life to HUF. We are not discussing about the legal formalities here, but we know that we have a legal concept called as Hindu Undivided Family. What is it? What is the part of HUF? It's husband, wife and the kids. They are the part of HUF, right? Now, the concept of illegal association permits. It says that HUF can also run a business. I hope you all know that, right? Even in taxation, HUF is conferred a separate legal entity. That means can, as an individual, I can run a business, and as my HUF also can run another business. That's a family business, right? So that is also permitted. Now, just say for example, HUF is permitted to run a business. Fine. Illegal association, the concept of illegal association says that if your association exceeds a certain number, you must incorporate it into a company, otherwise it will be treated as illegal. Fine. Now we have this association of HUF. We have a family. Although government always promotes this slogan, I hope you have heard of it, hum do hamare do, we too, our too, right? That is for controlling the population of the nation, that every couple should plan not more than 2 children, right? That is what government is trying to promote through different ways. If someone has the ability, to deliver, say 60 children, what can you do? Will you say that your family is an illegal association? Well, no, you cannot do that. If they have the ability to bring something like that, something unique like that, the government is not competent enough to say that this is an illegal association, and hence government permits the same. Government says if it is HUF, it will always be legal. So if you have an HUF with 60 people, with 60 members, if there is HUF which has 60 members, we permit it. If your HUF has 60 members, it will not be illegal association if they are doing the business. It will still be legal association. Fine. So there are 2 exceptions. There are 2 exceptions to the rule. First of all, let's read the rule. Let's read the general provision which is given in section number 464. 464. 464. 464. Repeat with me. 464. 464. 464. Illegal association. 464. 464. Illegal association. What is it? Any association consisting of not more than 100 persons shall be formed for the purpose of carrying business. That means if it is more than 100%, it will be treated as illegal association. But, mark my words, the current limit is 50%. So we have to check only 50%. Fine. So if there is any association, which is doing business and that the strength of that association is more than 50, it will be treated as illegal association unless it is registered as a company under this act or is formed under any other law for the time being in force. So if there is any other law which can permit such an association, fine. Otherwise, it's going to be registered as a company. It has to be registered as a company. So this is something which makes the registration of an association mandatory. We have a choice whether we want to form a company or not, but here we don't have a choice. If we are running an association like this, we must form a company. Get it? Now, as I told you before, there are 2 exceptions to this provision. What are the exceptions? The first one, Hindu undivided family. So if there is any HUF carrying on any business, the limit doesn't apply to HUF. If the HUF has 60 members, 65 members, 51 members, it's okay. It will not be treated as illegal association. Plus, an association or partnership, if it is formed by professionals, who are the professionals? We are the professionals. So we are governed by special acts. We are governed by our respective CA, CMA and CS Act, right? So we are governed by that act. Under that act, if we have formed a partnership and there are say 51 partners in that particular association, it is permitted. It is permitted even in the name of partnership. Why? Because if we incorporate a company, if you go on to read about auditors, supposedly ICAI members, there were 51 partners. Now, if they followed this particular rule and they incorporated a company is not permitted to do audit. A body corporate cannot be the auditor of the company. So they have to be partners only. No, a partnership firm is permitted. A company is not permitted. So they have to remain as partnership only. They have to remain as partners only. So they can go out and add on more partners. There's no limit to them, provided they are governed by special acts. Clear? So what you have to remember is the limit of 50 persons and these two exceptions. Fine. Section number 464. Section number 464, illegal association. Now, whether by choice or forcefully, we decide to incorporate a company. Fine. So we have decided that we are going to do some business and we have chosen our form of business organization as company. How do we do that? How do we proceed? How do we form a company? Section 1 talks about the short title and commencement. Section 2 is all about definition part. Section 3, it talks about the formation of a company. It tells that a company can be formed with 1%, with 2%, with 7%. Ma'am, earlier you told that there are just two kinds of companies. One is private company and one is public company. I also discussed the concept of OPC, 1% company. So if let's say for example, I decide to do my business of bottles and I don't have anyone around me, I want to do it on my own, but I want to form a company for the same. Can I? Yes, ma'am, why not? You can form 1% company wherein the requirement of member is just one. In private company, you need at least 2 members, you need at least 2 people. I won't call the term members as of now, otherwise you'll be confused. So I need 2 people, 2% to incorporate a private company. I need at least 7% to incorporate a public company, but I need just 1% to form OPC. OPC is nothing but a type of private company. So ideally we have just 2 types of companies, private and public. Fine. Okay. One interesting line which is written in section number 3. Let's read it. A company may be formed for any lawful purpose. Now, its interpretation can be two-way. A company may be formed. That means you can choose to form a company, you can choose not to form a company, and if you choose to form a company, it has to be for lawful purpose. That is interpretation number 1. The second one, a company may be formed for lawful purpose. That means, are you trying to tell me that a company can also be formed for some unlawful purpose? For some unlawful purpose, supposedly I want to start a company, Shivangi Kidnappers Limited. I am forming a company and I'm going to kidnap all the rich brats and then ask for ransom from their parents. I formed the company for the motive of my company, the objective of my company is that. Can I do so? Will law permit me? The answer is no. I will not be permitted to form a company like that, right? Because although the term written over here is may, it does not imply a discretionary force. See, may and shall, there are 2 terms, may and shall. You may go there. You may go there. It's like your friends are saying this. Your friends give you a lot of advice, right? Every sooner or later, they are there to give you advices. They're there to give you a number of advices, all this point ones, I believe. But still, it's your choice whether you follow that advice or not. You may go and propose to her. It's always may, because you have a choice. Supposedly your wife says, go and do this. Now you don't have a choice. Do you? You don't have a choice. That means whenever wife is saying something, it is always shall. You have to do it, you must do it. There is no choice, right? So shall is something which is a mandatory force, just like wife saying something, and may is something which has a discretionary force, like your friends are suggesting something. So here, if we read it as may, that means we can form it for unlawful purpose also. Well, the answer is no. So although it's written may, we are going to read it as shall. Sometimes the interpretation has to be different. These are all rules of interpretation which we don't have to read in our course, but we must understand when we are reading law. Fine. So company can only be formed for lawful purpose. It can be formed by 7 or more persons. That means minimum 7 persons if it is going to be a public company. 2 or more persons, that means minimum 2 persons if it is going to be a private company, and just 1 person if it is going to be a 1-person company. So if I have to form a company, I can form a company as OPC, private or public, but only for lawful purpose. If I want to form it as 1-person company, I need just 1 member, private company 2 members, public company 7 members at least. Fine. Now, there's one line which I'm skipping as of now because you will not be able to understand it. The one I've highlighted with green. Fine, I'm skipping it as of now. We'll come back to this line little later. I hope that's visible. Okay. Now, we come to the next concept. Promoters. Who are promoters and what is promotion? I have decided to form a company. Fine. So I have this business idea that I am going to sell bottles. I'm going to do it in this particular place because in this area the need for bottles is more and the people don't have access to such facilities, such products. Fine. So I did all that, my feasibility study, that I'm going to do this business in this area, in this manner, this is going to be my office, etc., etc. Searching for office place, all those things. I am the promoter. Mr. Ambani had this idea of incorporating a new company, or maybe Reliance entering into the petroleum sector. He wants to form a new company, Reliance Petroleum Limited, wherein he is going to do that business of petrol. So he had that idea, supposedly he had that idea, and he does not know that whether he himself is going to hold any shares of the company, or he himself is going to be the director of the company. Maybe he just has that idea that I'm going to form this company no matter who runs it. But I have this business idea, I'm going to turn this business idea into reality. So anyone who turns the business idea into reality, who undertakes all those preliminary steps, that person is known as a promoter. That person is known as a promoter, and that process is known as promotion. Fine. So promotion is nothing but the preliminary steps undertaken by the promoters to bring a company into existence. Okay. So how a company is going to be formed? The promoter, he gets that idea, he decides, okay fine, I'm going to form the company, but which company I should form? Which company I should form? Okay fine, I'm going to form a private company. So I have to arrange for that requisite number of people. I have to think of the place, office address, everything, right? I have to arrange for certain documents. So I am going to be known as the promoter. Clear? One quick view. A person gets a business idea and then decides the form of business organization. If he chooses it to be the company, he does all the preliminary steps necessary for incorporation. Now tell me one thing, if Mr. Ambani has got the idea that he is going to form or he wants to enter into the petroleum sector, will he fill the form? Okay, give me the form. What is the form for incorporating a company? Give me the form. I'm going to fill the form. Reliance Petroleum. I'm going to stand in the queue to submit the form. I'm going to deposit the fee. I'm going to do all those steps. No, he's not going to do that. He will instruct someone else to do that. Probably that person is going to be the professional, because without a professional's certification, you cannot incorporate a company. So CA, CS, CMA, you need CS or CA. You need the person to certify. Plus, you need the help of a professional to do that whole process. So, are we promoters? We are just rendering our professional services. We are not promoters. Mr. Ambani will be the promoter, or in my case, I will be the promoter. Supposedly, I am a CA also. Supposedly I am a CA also, and I don't have COP. I can do my own business. I have started the business, and will I be the promoter for my business? Yes, of course. Although I am a professional also, but I am promoting the company in the capacity as a promoter, so I will be the promoter. Fine. So a person gets a business idea, he decides to form a company, he undertakes all the preliminary steps, that is gathering people, minimum 1, 2 or 7 as the case may be. He prepares the documents, he may take help of some professional who are not going to be treated as promoters. He then decides the name of company. What's in a name? The name is the most important thing. When you listen to someone's name, you make a lot of presumptions. A name actually gives you a lot of presumptions. Supposedly, there is a phone call or a conversation which is going on, and someone on the line says, "Hi, I'm Shania." You will immediately have, okay, that modern image of that girl, okay. And supposedly someone on the phone says, hello, my name is Shanti Prasad Verma. What do you will think? Must be some traditional girl from a village. No offense to anyone, I'm just trying to explain you certain things, right? So a name also gives you a lot of impression. So the first thing that we are going to know about the company is its name. So when we know about the name, it has to be dynamic, right? Plus name has a lot of things involved for a company. We will read section number 4, name restrictions, then you will understand this better. Fine. So he decides the name of the company, he does all the filing with ROC, may also enter into incorporation contracts, etc., etc. Fine. So I think you have got this overview idea what happens. We come back over here. We have a definition. Of promoters. Now the definition does not tell us who the promoters are. Wow, ma'am, a definition which does not define promoters. Yes, it identifies promoters. Ma'am, as in, let's take an example. Imagine you're walking by roadside. Fine. You see a beautiful house. There is a nameplate outside the house which says Shivangi Agrawal. Fine. You know by seeing that nameplate that this house belongs to Shivangi Agrawal. Correct? Fine. Case number 2. You're walking, you see a beautiful house, you don't see any nameplate around. You enter into that house, you see a lady who is instructing everyone that you are supposed to do this, you have to do this, you come here, this has to be hung here, etc., etc., etc. So by looking at that person and by the way she is giving instructions to everyone, you come to know, or you make an idea that this girl probably, or this lady probably, is the owner of the house. So you go and ask her name, Shivangi Agrawal. So you come to know that, okay, this house belongs to Shivangi Agrawal. You agree with me? Likewise, Mr. Ambani, he promoted a company. He had an idea. He took all those steps and finally he brought that vision into a reality, and we have Reliance Petroleum. Now let's say, for example, a fictional case, he is not the shareholder. He is not even the director of the company. Fine. But when we read a prospectus, we come to know that Reliance Petroleum was founded by Mr. Ambani. So by reading his name, we come to know, oh, he was the promoter of the company. Okay. So by reading the name, just like the nameplate outside the house, we come to know that fine, he is the promoter. Second case, he is giving instructions to the board that you have to take this decision, you have to enter into this contract, you don't have to enter into this contract. Fine. So by the way he is giving instructions, we come to know that he is the promoter, just like Shivangi Agrawal was giving instructions. You get my point. So, promoter, the definition of promoter, section 2, clause 69 means a person who has been named in the prospectus or identified in annual return. So, how do we identify that who is the promoter? If his name is written in the prospectus or his name is identified in the annual return, we come to know that, okay, fine, this person is the promoter. Second case, who has control over the affairs of the company? So, who can control the affairs, whether as a shareholder, director or otherwise? And according to whose instructions the board is accustomed to act, the board is acting. So if any of the three cases, if a person falls in any of the three cases, we can say that such person is the promoter of the company who must have taken all the preliminary steps to incorporate a company. Clear? To incorporate a company. Fine. Okay, ma'am. Great. So, a person known as promoter. Such person is known as promoter. How do you identify a promoter? You can identify a promoter according to the definition by these three ways. The promoter does all these steps. Fine. Section 3A we will read a little later. Now, see, you want your PAN card, you apply for your Aadhaar, you apply for your license, passport, anything. For any ID, address, any proof, you need a bunch of documents, my dear. Fill a form. You want to apply for license, you want to apply for passport, fill a form. Attach these documents and then pay the requisite fees and submit the document at a requisite place. Then you will get your passport. You agree with me? Fine, ma'am. The same way you are incorporating company. You're forming a company, right? You have to do the same thing. You have to fill a form. You have to attach some documents. You have to pay that requisite fee and submit the document at the relevant place. Then your company will be incorporated if all the documents are found in order. Yes or no? Of course, ma'am. That's so simple. The process of incorporation is nothing. Right. The question is, license, for applying for license has a different website. For applying for passport, you have a different website. For applying for PAN card, you have a different website. Likewise, for applying for company, you have a different website. What is the website, ma'am? We have a website, mca.gov.in. Okay. Ma'am, the whole procedure of incorporating a company is online, yes, completely online. That means you don't have to take any physical form at any government office or counter and stand in queues to submit the form, nothing like that. Everything is online. Okay. So, promoter has decided that I want to form a private company. So, for private company has also gathered two people. They will all need their DIN and digital signature. DIN is director's identification number. I'm not going to deal with this right now because this you will get in the chapter of directors. So you will understand it there. Digital sign is nothing but since the application is online, the sign cannot be offline. So the sign is also going to be online. So online authentication, digital signature certificate, DSC. I think by far, as being the professional CMA finalist, you must understand what DSC is, okay? Now, how do we proceed, ma'am? We have to first apply for name reservation. Why, ma'am, for name reservation? See, I am Shivangi. You might know some other Shivangi also, right? Shivangi might be your sister, mother, some of your friend or your known relative, anyone, right? Likewise, if I talk about my son, his name is Reyansh, and I feel so unfortunate at times. Why have I kept this name? Because this name is so common nowadays. In his own class, in his own section, there are 3 Reyansh. So I get upset at times with this, but it may so happen, right? One name can be used by n number of people. There is absolutely no restriction to that. Fine. But have you ever seen 2 companies? Reliance is a group. So Reliance Petroleum, Reliance Industries, that's a separate thing. But if I want to form a company in the name of Reliance, can I? Never, ma'am, never, ever. You cannot do that. So, if the name of every company has to be unique, I hope you understand it will be difficult to get that name available. It's so difficult to get a Gmail username available, right? If we go on to apply, I want to make a Gmail ID today. I will try n number of combinations before I get that perfect availability, and that too it will be 2, 4, 6, any number, any special characters. I'll keep on adding, then I'll get a username which is available. So the name of company's availability is also a matter of concern. So we need to check whether a particular name is available or not. Fine, ma'am. So we have a web facility. What do we have? A web facility. We go to this particular website, mca.gov.in, and we have a form Spice Plus. It's a kind of web facility. This is divided into 2 parts, Part A and Part B. You don't have to read the whole incorporation process very detailed manner. I would have shown you the forms and all, but I have shown it at the interlevel. So Part A and Part B. Fine. Now Part A is all about name and Part B is about other details. So what you can do is, you can just fill this part and submit it. Once your name is approved, then you can fill this part and then you can submit it, or you can fill both the parts together also. That's also an option available. Now in part A, what you have to do is proposed name. Check the availability there itself. The name is available. Ma'am, if the name is available, why do we have to wait for approval? Because although prima facie the name is available, there might still be some problem with your name. What can be the problem? Your name, supposedly I applied for the name Shivangi Construction Limited. Shivangi Construction Limited. And the work or the object of my company, what business, the object, work, business, what am I going to do in that company, that I have written is sale of bottles, a retail trading of bottles. Now, don't you think the authorities will be quite surprised that you are doing trading of bottles and you want a name Shivangi Construction Limited? How is trading of bottles connected with construction? No, we will not give you this name, because this name will denote something else and it will give a wrong impression to whoever reads it. So this is all about approval. This is all about approval. So we submit the name for approval, and once we get that approval, our name gets reserved. So we apply for name reservation through Part A of Spice Plus and it gets reserved. Then we prepare the documents, because we have to submit an application. Application is nothing but Spice Plus. Plus we have to attach the docs. Plus we have to pay the requisite fees and we have to submit it to the concerned authority. ROC, we actually file it to MCA. It goes to the Central Registry Office, which is in Manesar, Gurgaon, CRC. I'll tell you everything. What documents are needed for the documents? The two most fundamental documents that are needed, first of all, Memorandum of Association and Articles of Association, MOA and AOA. What is it? MOA is the fundamental document of a company, a charter of the company, which gives you, just like for India Constitution is there, like for a company MOA is there. It tells us what is the name of the company, where is the company, what is the capital of the company, with how much money is it registered, what is the liability of the members of its company, and what is the company intended to do? Why is the company formed? What can it do? That is the object. So we have basically 5 clauses, my dear. Name clause, situation, object, liability, capital. What is the name of the company? In which state is it registered? Not the full address. The company belongs to this particular state. Object clause, what is the purpose for which it is incorporated? Liability, what is the amount that the persons have undertaken to contribute? The capital clause, and in case of OPC, we have an additional clause, which is succession clause. I told you before that in one person company, we must add the name of a nominee. So in succession clause, we write the name of nominee also. Fine. So memorandum is nothing but a document which is divided into 5 clauses, which contains the basic details about company. It's going to be printed, it's going to be signed, it's going to be divided into paragraph, numbered, it has to be prepared by every company, it is required at the time of registration, and it can be changed later on also. It can be altered later on also according to section number 30. Fine. Likewise, we have articles of association. Articles of association means what, ma'am? These are the internal rules of a company. How can the company forfeit the shares? Can the company accept call money in advance? So all those internal details. See, for memorandum as well as for articles, you have a model set of MOA or sorry, you have a model set of MOA and articles, model articles. That is, if your company is limited by shares, you have a specified model articles that these are the ideal articles. If you want that this rule be applicable to your company also, leave it. If you don't want, strike it off. Strike it off. If you want to change this rule, edit it. So we have a model articles, we can easily edit it, we can change it, we can strike it off, and then we can submit the same, not a problem. Fine. But it again can be altered also. It can be also changed later on. So articles are internal regulations for company's own governance. A company may adopt all or any of the provision as given in the model articles. It is also printed, divided into paragraphs, numbered, signed. It is prepared for every company, required at the time of registration, and can be altered later according to section number 14. Fine. So these are two basic documents. These are two basic documents. Apart from that, what will you need? You only tell me. What will you need apart from these two documents? Who is forming a company? We have found two people. I want to do that business of selling bottles. Me along with a student of mine, we both are trying to incorporate a company. So we are going to be the members of the company, first two members of the company as needed by the private company. So my details, his details, right, our details. What is our name, where do we belong to, what is our address, a proof of everything, right? Plus, who is going to manage the company once the company is formed? The directors. Who is going to be the director? I said we are only going to be the directors of the company. Fine. So your details are again going to be filled over there. Supposedly I say no, we are not going to be the director of the company. Someone else is going to be the director of the company. So his details, his ID, address proof, everything. Where the company is going to do its business, the address of company's registered office. So all these basic details are required. You fill the form, Spice Plus, Part B. You file the documents with ROC along with the fee. ROC gives you a corporate identity number that fine, your company is incorporated and this is your certificate of incorporation. Clear? Now, that means, ma'am, the process of incorporation over? No, my dear, no, this is just the beginning. Not dealing it in very much depth, mind it, huh? I'm just telling you the overview of the procedure of incorporation. Now, don't be concerned. I'm teaching it strictly according to the syllabus, so nothing will be missed out. Fine. Now, process of incorporation. The first step is to reserve the name. An existing company can also change its name at a later point of time. We all have this option, right? And many of our friends even go out and change their name before their class 10th. At the time of filling form of class 10th, they will change their name because they don't like the name. Maybe the parents have kept the name too long, or it's too outdated, it's too old fashioned, so we want to change the name, and we do that. So if we have the option to change the name, the company is also an artificial person. Company should also have the option to change the name. So company can also change the name. How can it do so? By using this web facility, reserve unique name. So it can also do that. Fine. If we are forming a company, we use this form. Fine. Now, whatever name we decide cannot be identical or resemble to an existing company. It just cannot be. it should not constitute an offense. As I told you, Shivangi Kidnappers Limited, I cannot keep a name like that, right? Or crush, let's say for crush Christianity, no offense to anyone, absolutely, crush Hindus, crush Muslims, anything like that. If I have made um, I have incorporated a name like that, that is not something which is permissible. It should not be undesirable according to CG. What is considered as undesirable according to central government is given under Rule 8A, but we don't have to read about these rules in detail. So we have to remember that it should not be identical, it should not be same to an existing company, it should not constitute an offense, it should not be undesirable. Moreover, it should not give an impression that it's related to government. We have central board of, let's say for example, we have CBSC, we have ICSC. Likewise, supposedly I also open a company, Shivangi Board of Education Limited. What impression is it giving? Board, the word board is used, that means it is a government company, right? So if I'm using such words which give an impression that it's a government company, I cannot do it without obtaining the approval of government. So I cannot use that word unless I obtain the approval of government, and this is something which is just not permitted. So as I told you, the name has a lot to do with it. So even if you check that a particular name is available, it necessarily will not be approved. It should be in line with your object clause. That means if you're doing construction activity, then it should coincide with the name construction or something like that. Plus, you have to keep in mind these name restrictions given under section number 4. Fine, these name restrictions. By complying with these name restrictions, you fill the form Spice Plus Part A and submit it to ROC. Now, although you are filing it with ROC, ultimately this incorporation application goes to our central registry center, and from there all the companies are incorporated and then they are handed over to the respective ROCs. That means, supposedly I live in Varanasi, supposedly I don't live in Varanasi. Supposedly I live in Varanasi and I want to incorporate a company over there. That means I belong to the state of Uttar Pradesh. So do I have to take my form to ROC Uttar Pradesh? Well, physically I'm not going anywhere. I just fill the application, submit it online. In that, I'm going to submit the jurisdiction also that I belong to ROC Uttar Pradesh. Right? Now, all my records will be kept with ROC Uttar Pradesh once my incorporation process is complete from that central registry. Right? And then I'm going to coordinate. I do everything online only, it goes to the concerned place. Now, if my application has some defect, I will get a chance to remove the defect within 15 days. If there is no defect, it will be approved. Part A of Spice Plus has been filled. That means my name has been reserved. There are two possibilities, my dear. My name will be reserved for 20 days and now I get the time period of 20 days. Within 20 days, I can fill Part B also and then my company will be incorporated. If I don't fill Part B within 20 days, then the name reserved will be cancelled. Fine. Clear? Now, for existing company, the name reserved is for 60 days. Now, if it is found later that the name I reserved was by furnishing incorrect particulars. I reserved my name saying I want this particular name, but I was not going to do that activity, that object. I wanted to do some other business and I reserved the name for some other thing. So There are two possibilities. If you give any incorrect information to me, I might catch you there itself before the thing is done or after the thing is done. That means I have given incorrect information to ROC. Now, maybe my company has been formed, my company has not been formed yet. And before that, ROC discovered that, okay, this application has come with some incorrect information. They will immediately cancel my reserve name and a penalty of 1 lakh. Fine. Supposedly I succeeded and my company is also formed. Don't be so happy. Still, ROC will give you an opportunity of being heard and may direct me to change my name within 3 months or may strike off my name. They have a record of the companies, may say that this particular company does not exist or may tell me to wind up. Sell your assets, pay your liabilities and just close the company, wind up. So they can pass such orders also. That means whatever details we are furnishing, we must furnish with correct details. If I want to reserve a particular name, I must provide correct details and then only I should reserve my name. Okay, ma'am. Now, after my name has been reserved, or if I decide to fill a Spice Plus, both parts together, that means I have not pre-reserved by name, the company's name. I am deciding to fill both part A and part B together. In both the cases, I have to prepare the documents. What documents? MOA, AOA. Now you know this, right? You also know the details of office, subscribers, directors and their consent that they are ready to become the directors of the company. Here I have to tell you two things. Firstly, I've got exactly what I wanted to. We have these three concepts in which students are often confused. Ma'am, what do we mean by subscribers? Are subscribers and shareholders and members same thing? The answer is no, they are not same. Then ma'am, what is the difference between subscribers and members? See, we are talking about company which is not even incorporated, company which is not even in existence right now. So we cannot say that they are members of company. They are prospective members of the company. They are future members of the company. I am going to form the company. I am the prospective member of the company. If the company will be formed, then I will become its member. So what am I now? I am a subscriber. Why? Because I am subscribing to the memorandum. I am signing the memorandum that I agree to become the first member of the company. You get my point? So right now I am the subscriber, as and when the company gets incorporated, I become the member. And after the company is incorporated, when the company will give me shares and I will pay money for that, then I will become the shareholders. In the companies where there is no share capital, there are no shareholders also, but there are members who have subscribed to the memorandum and they have become members. Clear? Now, one more document which is needed. Memorandum and articles. Declaration by the professional that all the rules of the Act have been complied with. It can be a chartered accountant, it can be a cost accountant, it can be a CS, right? It can be an advocate also. So we need some professional to certify that all the details are correctly filled in. So you can also incorporate a company. Now, a declaration from the subscribers and the first directors that we have not convicted an offence with the promotion of the company, of any company. That means we have never in past tried to form a company or in a fraudulent manner. So we are good citizens. In short, you are just giving a declaration and a confirmation that we are good citizens, we are good people. We have never done any fraud in last 5 years. Okay, under this act or previous company law, and all the documents that we are filing has information which we believe to be true. So we give this declaration, the subscribers give this declaration, professional also gives a compliance declaration that the requirements of act have been complied with. So we need a memorandum, we need articles, we need a declaration of compliance, we need a declaration of no offence by these people, and we need these particulars. All these documents are prepared and the application is submitted to ROC. ROC gives us a certificate that finally your company is incorporated, and we get a unique identity number, corporate identity number, a unique one, which is going to be unique for every company. Fine. So what do we do with the documents that we have prepared? Ma'am, we have submitted all the documents. What do we do with it? We have scanned the documents and submitted. We have the documents original copy. What do we do of that? Destroy it, discard it. Don't ever do that. You have to preserve these documents till dissolution. Right? Now, we file the documents and information with the registrar. There is a clause about this address. We will read about this particular clause when we read section number 12 in detail. Certificate of incorporation is issued, SIN is allotted. We have to maintain all the documents. Now, one more thing. If it is found later on, see, we have read that if it is found later on that name was reserved by furnishing incorrect particulars, we have some penalty. Likewise, if it is found out that you have incorporated a company, or you have given the form for incorporation with incorrect details. Maybe you have given incorrect address, maybe you have given incorrect details about the director or anything like that. So if it is found, there can again be two situations. The company is not yet formed. Whoever is the person will be responsible for section 447, which is a section you write over here, which talks about punishment for fraud. So under Companies Act 2013, we have a section 447, which gives us the punishment for fraud. So whoever has submitted the application with incorrect particulars will be punished under section 447. And supposedly the company is formed. Now what do? We gave incorrect details and the company is formed with those incorrect details only. The promoters, the directors, subscribers, they all will be liable for fraud. Plus, if an application is made to tribunal may say that now I am going to regulate the management, because the directors that you have appointed are not competent enough. They are indulged in fraud even before the company is formed. How will they manage the company thereafter? So we will regulate. It may pass an order that these members, their liability will be unlimited, Because if they are doing fraud even before incorporation, after incorporation also they will continue to do fraud. So we don't want the creditors or other parties to suffer. So now their liability, which was earlier limited, will now be unlimited. It may also remove the name of the company. It may pass winding up orders that wind up the company or other orders as it may deem fit. Fine. So if you furnish incorrect or false information and the company is not formed, or the company if it is formed, the tribunal may also pass these orders. Fine. Now we have a small section number 9, which I have already told you indirectly, that from the date of incorporation, that as and when a company is formed, the subscribers become the members of the company and the company becomes a company. So it will now be perpetual succession. It will have the power to hold property in its own name, capacity to sue, be sued, and all those things. Fine. So that is the effect of registration of an association. Right, so it has now become a company and all the features of a company will be applicable to it. Section number 9. Clear? This we'll do later, but we have a section whose chart you will find over here, slightly above. Members liable in certain cases. Section number 3A. The section is after this, but the chart you will find it before only. What is it? See, there is this minimum requirement. Minimum requirement means what, ma'am? We have like in case of public company, at least 7 members. In case of private company, at least 2 members. And 1-person company, there will be 1 member, right? Obviously. So at any point of time, these are the minimum members which must be there. There can be more than that, but this is the minimum requirement, statutory minimum which is required. What if the number of members gets reduced? Why will the number of members get reduced? Supposedly, I formed a company with 2 members. 2 members. I formed a private company with 2 members. Now there is just 1 member. But a private company needs 2 members. Can this be a possible case? Of course, ma'am. Why not? This is a very well possible case. Now, what is going to happen? The company gets a time period of 6 months that acquires someone's membership. Make someone your member. Make someone your member and that person will continue. So you have to always get back to the minimum number of members. That means if the minimum number of members was 2 and now your current number of members is 1, you have to within 6 months make it 2. If you don't do that and continue your business even after 6 months, then every member, supposedly that 1 member, there is just 1 member, so that 1 member will now be liable, personally liable. After 6 months, you had the time period of 6 months, you could not get any member, fine. After 6 months, you continue business. If you enter into any contract, for this particular contract, you are going to be personally liable. So if the company incurs losses, you have to pay for these losses even from your own pocket. You get my point? If at any time after incorporation of company, the number of members is reduced below 7 in case of public company or below 2 in case of private company, then if business is carried even after 6 months with reduced members, every member who knew this fact, supposedly I don't even know that the company is running, I am on my, or not me, Supposedly, it's a public company, the number of members has reduced below 7, and one of the member is taking a trip abroad. He does not have any idea what is happening in the company. So if he does not have any idea, how can I make him liable? The law can also not make him liable. So every member who knew this fact and they are continuing the business even after 6 months, they are going to be liable for debts of the company contracted during that time. That means after 6 months, right? So that's a small section. The members are going to be severally liable in certain cases. In this case, section number 3A. Clear? So I think so far the provisions are clear. The process of incorporation is clear. Right? We will commence with the next section in our next class. Thank you so much.